Hi, friends. Welcome back. My name is Carly Jones, and I'm an employment attorney at the Manifest Justice Law Corporation. Today, I wanted to talk to y'all about the stages of an employment lawsuit. I like to break it down into 8 steps for my clients with some kind of like pit stops along the way, exit ramps or off ramps, if you will. But there are a lot of different ways you could break it down. But either way, the processes and the various like stages, steps, the way you'll go through it is the same, but how each attorney breaks it up or the different stages or names that they call it might be different. I am so happy with this time of the year because it's like, at least when I'm recording this video, it's that perfect time right before summer. It's before that time where all you can wear is a bikini and a tank top, but it's after that time where it's so cold in California that all you can wear is like a jacket and a jacket on top of that. So we're like moving away from layer season and we're not quite into like blazing hot season yet. So it's the perfect time for scarves. You're going to be seeing a little bit of my scarf collection and let me know what you think. Okay, but no, seriously, we're going to focus on employment law today. So I have, again, 8 basic steps that I like to break employment lawsuits into. The process, the stages. We'll talk about that again, and these stages are like very much in flux. This is not a hard definition by any means. But the first stage, so I'll just go through all 8 and then we'll dig into it a little bit more. We have the first stage is retaining an attorney. Then we have second stage is investigation, third stage, and I'm reading off a slide here. So if you see my eyes darting, it's because I'm reading off of a presentation. I don't have these memorized. And I would skip the shit if I tried to do that. 3, we meet and confer. 4 is when we file the complaint. 5 is for negotiations. 6 is discovery. 7 is trial. And the 8th and final step is judgment. Let's walk through those a little bit and dig in. Because as I said, there's also like plenty of pit stops and off ramps in between all of that. Obviously, first something will happen at work, right? Something will happen at work, you'll report it, you'll try to get help at work, they will ignore you, they will gaslight you, they will shame you, they will isolate you, they will black sheep you, and they may demote you, they may send you away, they may transfer you, they may get rid of you entirely, but then there's some kind of like adverse action that's taken against you. And so you realize, yeah, your employer is not going to help you through this situation. They are not going to act reasonably or responsibly. And so you start looking for counsel. As we've talked about on this page plenty of times, when you look for counsel, it's a long arduous process, and we speak to multiple attorneys during that process. So finally, we've selected the attorney that we trust the best and that we've investigated and done our back homework on. And we're like, yep, everything checks, looks good. I like how I spoke with them. Seems like I can trust them, like how we work together. Let's move forward. That's the attorney I'm going to hire. So, 1, you've made it to step 1 of the employment lawsuit, employment litigation process. We're in step 1. We've retained an attorney. Retaining the attorney means you've signed whatever fee agreement there is, which is attached usually within the retainer agreement, and you've consulted about your matter. You sent preliminary information and documentation over to the attorney so that they can verify at least preliminarily your claims, and you begin the onboarding process, whatever that might be for whichever firm or attorney you're working with. So stage 1, you retain the attorney. You sign the paperwork. You say, yes, this is the one I want to work with. You come up with the fee agreement, some kind of strategy, sending some basic documentation. That's your lawyer. Confidentiality, relationship established. That's your lawyer. Okay. Step 2 of the process, investigation. The second step. So we've retained the attorney, and now the attorney is going to investigate. You are going to help as the client a little bit. Another video I should probably make is like, why is my attorney always asking me to get this evidence gathered up? So I will make that next. But as a client, you are responsible for helping put that case together. Again, even just in the retaining stage, you have to have some form of documentation that you can give the attorneys that can help verify your claims that you're asserting. So stage 2, now we're doing a deep dive. Now I want you to send me everything in the book that you have. I want to know all of the documents you have, all of the screenshots you have, all of the text messages and pictures. And I'm going to start putting together a strategy, and we'll start figuring out timelines, and we'll start extracting the most key highlight information out of all of the documentation that you've given over to your legal team. and we are deep in investigation. We might start talking to witnesses and getting affidavits signed. It's full investigation mode. That's the second stage, diving a little bit deeper into the claims, into the clients, into the separate opposite parties of who you're suing and the employer, and investigate. Okay, stage 3 is meet and confer. I talked a little bit about meet and confer in some of my other videos about like commonly used legal terms, legal jargon that attorneys use and throw out, and like what does it all mean? So meet and confer is one of those terms. It's a stage in the employment litigation process where both sides have to come together and try to work out and resolve these claims before we go ahead and bring it in front of a judge and ask for court resources and like court intervention. So whether this happens before filing the lawsuit or directly after filing the lawsuits, some different states and jurisdictions have different rules about when meet and confer must take place, and some are a little bit more flexible. But in general, the concept or the process of meet and confer is when both sides of the lawsuit, the both parties, usually just the lawyers, usually the clients don't need to come into this part, but the lawyers will meet and they will try to work through the differences and see if they can't come to an agreement. And usually we can't. And so then at that stage, then you'll move forward and you'll either file the lawsuit, or again, you have already filed the lawsuit. And so you'll move forward with like, okay, we're going to do more investigation. We'll go into whatever. It depends on where you're at. So number 3, stage 3 is you meet and confer. You meet, you try to talk it out. It's very, very case specific on how it goes, but typically things aren't resolved. And then again, depending on your jurisdiction, after you meet and confer, then you would file the lawsuit. This filing of the lawsuit or filing of the complaint will initiate the official lawsuits. Once you filed the complaint with the court, this is like, we are suing them for X, and we have to have a well-pleaded complaint, and it has to like state the facts of of the matter and show enough facts that like, yes, there was some kind of legal violation. It has to talk about the laws which they think were violated, and then has to like speak on some kind of a recovery of like, what do you want here? What kind of money? How much? You file the lawsuit, and then the bosses, the other side, the defense, the company, the employer, they will respond. And usually it's just a blanket response basically saying like, we didn't do this. They're a liar. So prepare again for like gaslighting, shaming, isolating, all of that, denying, denying, denying. Don't expect them to answer and be like, yeah, we did it. So we've retained our attorney, we've investigated the claims, we've met and conferred, we've filed the complaint, and now step 5 is negotiations. Negotiations is a very, very broad term on purpose. It can be anywhere from like an informal negotiation, casually between two attorneys, trying to negotiate the claims, talking about the evidence, bolstering to each side and saying like, we're going to get you here. And then they're like, no, we're going to get you here. And you don't have it, and blah, blah, blah. So it's two attorneys going back and forth negotiating, or it can be a more formal process, which is more like mediation. And again, I've talked about mediation in past videos. But mediation is when both sides come together and they actually hire, typically for the day, or however long it takes, they hire an independent, completely neutral third party who to come in and try to, again, with the claims, to resolve the legal matter between the two sides. And that's a very formal process. There's steps that go into that. And if you want to know more about mediation, you can watch the mediation videos. But negotiation is step 5, an official or unofficial stage where now after we filed the lawsuit, we come together again and we try to say, okay, we still want to stand by this. You ready to go forward? Like, gloves are on. They still want to go forward. Then we move from negotiations and that mediation or stage into discovery. Discovery is like, okay, we've tried to resolve this now multiple times and neither side is seeming to budge. So we're going to go forward and prepare for a lawsuit. When we go to trial and have trials in court, we go in as an open book. It's not typically what you see in like the movies and TV shows where they have the like big smoking gun and the other side's like, what? Oh my gosh, how did you get that? No, we walk into a lawsuit with an open book. It's an open book test. Each side in general knows what kind of evidence is coming out. They know which witnesses are going to be called and generally which questions are going to be asked. And the reason that we know is through this discovery process. The discovery process is the stage where you gather even more information from the other side. You ask them specific interrogatories or like questions, and you do depositions, which again, I've talked about interrogatories and depositions in past videos. If you want to know about that, watch the past videos. And if I didn't do a thorough enough job, leave a comment, let me know, ask your question, and I will answer it, get back to you. But basically, in discovery, it's the process of grilling the other side, and the other side gets to grill you and your client, or like your client. And so it's the process of sharing and exchanging information in preparation for trial. So this is where things heat up financially. This is where things heat up emotionally. Each stage, it's ramping up continuously, but discovery process is really where we can go at it for a myriad of reasons. It can be even more intense than going to trial in and of itself, specifically, especially the deposition stage. So that's something to note. But we've made it to discovery. That was stage number 6. Stage number 7 is actually going to trial. No, we're not at the end yet. That doesn't finish the lawsuit going to trial. That's just now we're going to trial. There could be any levels of trial. There's like lots of kind of stepping stones and pauses in between, and like details around what it takes to get to trial. But in general, again, bird's eye view, looking at the process at large, the next step after discovery would be going to trial. This is where now basically all the witnesses that were called and questioned during discovery are going to be called during the trial. Maybe some additional witnesses, maybe some additional evidence has come out since then. We're going to have a jury unless you've waived your right to a jury and either party doesn't want the jury. We're going to have a judge there. We're going to have court reporters. We're going to have transcripts made. Everything's going to be very official. Everyone's going to be sworn in. We're all going to be in our best suits and attire. There's going to be presentation of evidence, and we're going to go back and forth. This is where we're going to have objections, and the judge will rule on those objections in the moment. And so it's a full-blown trial. The thing about trial is that it can be paused and stopped or settled at any time. So trials can end on a dime, and they could even, right before you're about to walk in and start trial, end right then and there. But it is the most expensive, most time-consuming, most emotionally exhaustive process. This is like the highest stakes at every single level. This is going to be taking the most of a toll on both the client and the attorneys, and opposite side as well, but it's just the most taxing part of everything. And again, you've already at each stage been ramping it up. So by the time you get to trial, you've already gone through the ringer if you get to that point. The final step, the 8th step, is judgment. Now, judgment is when the lawsuit is essentially over. But of course, there's still the opportunity to appeal, and then a lawsuit, the actual issue can go on for many years after a judgment. But at the like basic level, you've hired the attorney, you've investigated, you've met and conferred, you've filed a lawsuit, negotiated, discovery, trial, and now the jury goes and they debate, and then they come back with a judgment and they say, boom, here's who we fined for, and here's how much so-and-so owes the other person. And a judge says, yes, I agree. And more often than not in trial, the judge will be like, no, that's too high or that's too little. And they'll like assert themselves and adjust the judgment award. But that will conclude the lawsuit. Again, if either party is not happy with the judgment or the award, then there can be an appeal. And then if they don't like the appeal, then there can be another appeal. So like there's different court systems of hierarchies where we can continue to all the way to the Supreme Court if it's that serious of an issue. But typically that's where an employment lawsuit is going to rest, is right after the judgment. That's done. Now, the caveat is that in between and in the front and back of each of these stages, 1 through 8, is the opportunity to settle. Most cases, I think it's like 95% or 97% of cases, something like that. This is 93. It's 90s. It's in the 90s for sure. And I think it's even mid to high 90s% of cases that settle, especially in employment litigation. So most lawsuits do not go to trial. They may work their way through discovery up to trial. And as I said, like right when it's the day of, we settle, or right the day before, we settle, or one day in, we settle. Very rare. So that's really important to know. And like there's not a specific stage at which settlement more likely happens than not. It can happen after you've hired an attorney and now your employer gets scared and they're like, oh shit, she wasn't playing around, we better settle this. It can be at meet and confer where the attorneys come together and then the attorney's like, oh shit, they're not playing, you better you better settle this before they file and it becomes public. The Diddy situation, then it can be like, oh shit, I better settle this or else my life is going to implode. It could happen after negotiations and after you come together and hear each sides, and then you hear this neutral third party in mediation say like, are you kidding? You better settle this right now. And then they get scared and so then they settle. So it can happen in discovery after depositions or right before someone's deposed, right before leadership is deposed, typically, or right after they've been deposed, right? We'll settle so that that doesn't have to go any further and they don't have to perjure themselves in court. There are so many times at which a case can settle. In between every single one of the stages that we've talked about today, a case can settle and it likely will. It likely will settle. So, if you are someone who's super hung up on like having your day in court, or you were like really looking forward to that, and that's like the reason you settled, that is the reason you hired an attorney and that you are filing a lawsuit, it's really important that you have that conversation with your attorney from the very beginning or as early as you can in the process so that they're aware and they can shape their strategy accordingly. And also, it's important that you let your attorney know that so that if they're an attorney who is like a flipper, an attorney who wants to just flip the case and settle it as soon as possible, and they're not ever planning to take it to court, that's important for you to know so you can go ahead and fire that person and go find a real attorney. Okay, I think this is a lot of information. Hopefully it was helpful. Hopefully it was informative and empowering and it somehow helps you get paid. If you feel like this was confusing in any way or you have questions or just like want to talk about any of this more, please leave a comment. Let me know. I will make you another video as soon as I get the chance and we will kiki it all up. If this was helpful to you and you felt like I did a good job, I also want to know that. So please feel free, give me a like, give me a share, give me a comment. Let me know. Okay, that's what I have for you today. I hope you'll have a good day. Just know, everyone works. Not everyone is safe at work. And I'm trying to really make sure you guys know the difference for real. Have a good day. Bye, guys.